Under such circumstances, in view of the judgment referred above, this court holds that the primary issue raised by the petitioner, that the appeal filed by the private respondent before the appellate authority under Assam Town Act 9 and the contention of the petitioner that the appellate authority has no powers to due jurisdiction, therefore cannot be accepted. The contention of the learned counsel for the petitioner therefore failed, and the writ petition stands dismissed. Interim order earlier stands vacated, no order is enforced. Appellate authority will now proceed to decide the appeal filed by the respondent and dispose of the same expeditiously. The question of whether respondent 4 is an aggrieved party under the so-and-so act will also be addressed by the appellate authority while considering the appeal. Writ petition accordingly and closed off in front of
Much.
May I please, Your Lordship, I beg to mention item number 26 and 27 today's date. Due to some personal difficulties of my senior, kindly the matter may be taken up after due vacation.
20,
26 and 27.
26, 27 on behalf of petitioner,
Of the respondent.
respondent.
And for the petition,
Any objection?
no objection, but I'm paying for a date, my lord.
Right, matters deferred to be listed again on 30 April.
My lord.
Yeah.
Oblige.
May I please, Your Lordship, with regard to item 14, I beg to mention for adjournment because my senior is having some personal difficulties today.
1414.
Yes, Lordship, we have taken the consent of the petitioner.
You're mentioning on behalf of
Detail Das, respondent number 1.
item 14. Any objection?
No, lord.
Deferred to be listed on 30.
Obliged, Lordship.
The contempt petition, madam. Under violation, there is a issue like more than 1 year, but it is a continuing contempt. And I am relying on a judgment of this court, Supreme Court, my lord. If it is a continuing contempt, my lord, section 20 of the contempt of the act will not.
We should notice
At
that
this
this-
issue, notice.
Yes. 4 weeks. Steps on respondents by registered for city
Right.
and usual court within 1 week.
Deeply out.
Item number 2, Lordship, I have prepared the affidavit, send it for vetting. Within a period of 2 days, we will file it, Lordship.
Today is the vacation will come. Today is fixed for interim order.
Otherwise, Lordship, instruction is received, we have prepared the affidavit, Lordship. Affidavit is necessary.
What interim order is the one?
There is a FP appointment of FP dealership.
What dealership? FP.
Yeah, FP Fair Price dealership. Without any selection, without any my lord interview, nothing else. Directly my lord on the recommendation of concerned minister.
Lordship, I have already sent it, Lordship. My lord may fix it immediately reopening.
But what happened to the prayer made? What is the prayer made?
Lordship, already it was done, Lordship. Already it was given, Lordship. License is given, Lordship.
License given, but allotment because
License is given.
the Fair Price shop is undertaken with another Fair Price shop.
Some factual facts is also there, Lordship. I will bring it to you.
Without anything, my lord, my application is also pending.
Who is respondent 6?
In favor of respondent 6, that another 7 was issued. Without any interview, nothing else, on the
Otherwise,
recommendation of
Lordship may issue formal notice. In the meantime, we will file it.
Let it be subject to outcome because you have already arranged respondent 6.
Respondency, but the thing is that on the recommendation of minister, my lord, your lordship will find application needs to be filed through the concerned cooperative society. And your lord, the application though mentioned,
Where is the order?
yes, order is at page 42, another 7.
It was passed on board.
Lordship.
We immediately have filed, my lord, but that they have taken this is the third occasion, they are taking time, my lord.
I have obtained, I already prepared the affidavit as private respondent is there, Lordship, he should be heard, Lordship.
Pursuant to this, what steps have been taken?
Already given, Lordship.
What stay can be
Lordship.
done? Given.
Otherwise,
You can make
Lordship,
it subject to outcome if you want. But notice is not issued.
not issued.
Not issued, my
So, Lordship may
So
issue formal.
instruction received, then on the next day, they have that said that the affidavit is ready.
We'll issue notice,
Yes, my lord.
issue notice, return and copy. Mr. Gogoi, A. Gogoi, here to the
Lordship, I am for 1 to 4, Lordship.
1, 2, 3, and 4.
4, Lordship.
Step to respondent 5 and 6. File extension daily. And you will vote. Then Mr. Gogoi, represents respondent 1. Because the way the copy of the cartridge within a period of 1 week. The petitioner is agreed by the order implement dated 4th of February 2025, by which the respondent 6 was appointed as the new dealer in the vacancy arisen due to resignation submitted by the existing fair price of dealer
Sunil Datta, my lord.
deal under MS
Bajanti, Rangilkhari Bajantipur Cooperative Society.
Bhajan Cooperative Society, page 42 side. Let the respondents complete their instructions and find necessary evidence.
Even Lordship, month of April, right?
Any consequent, any orders, the orders passed, impugned order dated 4/2/2025 and other subsequential orders shall be made subject to the outcome of the review.
And also that particular dealer has already distributed the month of April rice also, Lordship.
We'll see
Lordship.
after returnable.
Lordship, Lord. Oblige, Lord.
I was supposed to, Lordship, in this case, technical base is been open, but all is being stalled due to election, Lordship, in Panchayat election. Nothing is done nowadays, or what was being asked to take the latest status of the bill. Technical is being taken, but it was not open due
Who's
to
running it now?
this khas, Lordship. Because they
Our period has been expired in the third, 30.
we have
first of
issued
March.
NIT, Lordship. So,
What is
Lordship,
your ground for challenge?
No, we have not challenged, my lord. We have our grievance, my lord, that fishery was, my lord, settled with the petitioners, my lord, from, my lord, 4/1/2019 for 7 years. And our period was up to, my lord, March of 2025. During COVID period, my lord, we were completely out of operation, my lord, as per departmental instruction. And we have been allotted, my lord, some work for development of the fishery. We have executed, bill was submitted, bill was approved. It was not adjusted. Therefore, my lord, we submitted representation, my lord, for consideration of,
Are you also an intending tenderer in the new process?
no, my lord, because final settlement was not made, my lord, regarding our claim. Then we approached this all court. This all court, my lord, protected and
What
Ask-
what is your instructions with regard to the claim or final settlement?
regarding this bill, Lordship,
What
Yeah.
is his claim is that the final settlement has not been made. Certain amount is required to be passed.
no, Lordship, that
Receipt.
amount is something different, Lordship, regarding development of bills which were done without tender anything. For that, vigilance inquiry and enforcement director case is also pending, Lordship, for this part.
Tender in his favor.
In
earlier.
his against this, because they have this order, we pretended this order is a vague order.
Which order?
This adjustment factor. He has annexed some document.
Work order is at page 28, my lord.
28, that work order. This is in the Vigilance and Anti-Corruption Department, Lordship. And
This, according to you, this work order was issued in favor of the petitioner.
yes,
Lordship.
Lordship. This is separate, something this is separate for, this is not related with the development, not related with this NIT, Lordship. This is
Okay.
with this work order, around some crores of rupees, around 10, 12 crores, 25 crores of rupees, all over the bill, Lordship, is being siphoned over, Lordship. For this vigilance inquiry is going on and ED case is also.
What
being
is the amount that you are
10
asking?
lakhs, my lord.
This amount?
Yes, my lord. 10 lakhs, and we paid, my lord, that the COVID period may be granted
COVID pe-
remission, my lord. Or, my lord, we may be granted extension for that period.
This part, Lordship, I have a
So, my lord-
specific instruction, Lordship, that this Lordship, I can file an affidavit, Lordship, regarding this part, Lordship, this 10 lakhs part, Lordship.
Where is your settlement order?
Settlement, my lord, proposal page 19. And agreement page 22, my lord. Page 19, annexure 1, my lord. Settlement was after the process of tender, my lord.
No, but how these two things are connected? Page number 19 and 28. These are two different issues.
No, 19, there is no dispute, my lord.
Ah,
19 is formal settlement. We
Right.
took over the fishery.
ah.
Then, my lord, COVID started. During COVID period, my lord, we were kept outside and developmental work was allotted, my lord. During our tenure.
Ah.
So we have completed the work as per their instruction, my lord.
You have no quarrel against the settlement
No, no.
issue.
They have also no quarrel
Ah. So
regarding
your
settlement
only
part.
grievance is page 28 amount has not been released.
And, my lord, secondly, my lord, the COVID period, my lord.
Whatever.
Lordship.
But then why are you challenging the settlement?
We have not challenged, my lord.
Ah.
We have not challenged settlement.
Then?
We are praying, my lord.
What exactly are you submitting, Mr. Sharma?
We have not
I
challenged.
am submitting, Lordship, that regarding his 28 part, Lordship, 28. This is under investigation, Lordship. This 28, page number 28.
No, you
can-
mentioned about some affidavit being filed, etc. What is that affidavit?
No, Lordship, no, Lordship.
That issue
Lord-
was, my
last-
lord,
If,
last
if
order-
Lordship,
Last order has permitted you to get instructions.
yes, I got the instruction.
What instructions?
I got the instruction that Lordship, regarding COVID period, COVID part, Lordship, this is a totally matter of disputed fact, Lordship, evidence part, Lordship, we never, and this is not a part of the agreement also, Lordship, NIT. So we never
This is
considered that COVID
COVID
part, Lordship.
COVID was
COVID
natural
lost,
calamity.
Lordship, and after a gap of, after 5 years, they have pleaded for this. This is my instruction.
Our
Lordship.
lease was
And regarding
existing, my lord.
28 part, Mukul, regarding 28 part, Lordship, that part, we
Hmm?
28, this is development works, Lordship,
Yes.
that is not related to this, that we cannot, that we disown, Lordship, this amount, because this amount is being taken away,
You
Lordship.
file your affidavit.
Lordship, kindly see page 39, earlier writ petition, my lord. This all court directed them to consider, my lord. Even then, they have not considered, and station IT has been. Page 39.
Even Lordship, in this case, Lordship can dispose of with a direction. We are not settling it because of election, Lordship. Before settlement, we can dispose of this, his representation also, Lordship.
No, but there is already a direction. Why have you not decided it?
Lordship, that
You are
is-
exposing yourself to contempt.
Lordship, that part I don't know, that I forgot it, Lordship. I
Huh?
to take the
You
instruction,
forgot to take instructions.
that this regarding this part, whether
You take instructions. Come back on Friday.
after Bihu, Lordship.
All right. Immediately after reopening.
Okay.
21st. Mr. R. Ali for the petitioner, Mr. P. Sharma for the fishery department. Mr. Sharma is permitted to further time take instruction as to the status of the representation dated 8/2/2023, which was directed to be disposed of within a time frame by order dated 12/6/2024, passed by coordinate bench in WPC 1388 of 2023. Stop. Learned counsel will apprise the court as to whether the said order was carried out. Placed accordingly on 21st.
May I please ask? This is also relating to settlement of fishery losses. If the petitioner was settled the fishery for a period of 6 years, and that was supposed to be started from session 2016-17. But due to some litigation lordship, they have handed over the fishery only on lordship 1/11/2017. But I have given the lordship a revenue for the whole year. For 7 month excess amount that has been lordship taken from me.
Some representation is filed.
Presentation is filed and thereafter lordship this honorable court lordship in another writ petition lordship page 53
Hmm.
directed to consider the same.
No,
But-
you get instructions here. We are fixing
Lordship,
it
we
on the
have,
same page.
we have passed the order, Lordship, 56,
Huh? 50,
56.
56.
Lordship.
Okay. You had come earlier before this court.
Yes,
Now you're putting to challenge this order.
yes, lordship, this order is challenged.
We'll issue notice here. What else?
They were directed to obtain instructions relating to lordship on the last occasion, the 7 month lordship revenue that has
Lordship,
been,
here, my
They
learned
have
friend,
already rejected this, your representation.
that part has not been considered lordship.
Which part?
Lordship regarding
They
lordship,
says clause number 23.
case lordship,
Where is the agreement?
page
agreement
23,
lordship,
page 30, Lordship.
agreement page 23. Lordship,
Page 30, it is in vernacular, Lordship. He has not translated it. Page 20, clause number 23. দ্বিতীয় পক্ষে বানপানী খৰাং মাছৰ বেমাৰ বলপূৰ্বকভাৱে অন্য লোকে মাছ ধৰা বিষক্ৰিয়া চুৰি হোৱা মীন মলৰ বেদখল চমজি নোপোৱা নতুবা অন্যান্য প্ৰাকৃতিক দুৰ্যোগৰ বাবে হ'ব পৰা লোকচানৰ বাবে প্ৰথম পক্ষক দায়বদ্ধ কৰিব নোৱাৰিব আৰু এনে ঘটনা আদিৰ পৰা দ্বিতীয় পক্ষ লোকচানৰ ভাগি হ'লেও তেনেবোৰ অজৰত মীন মলৰ ৰাজহ ৰেহাই নাপাব। Then also, Lordship,
they have obtained lordship excess amount from me. The fishery was handed over on 1/11/2017. But I have given the revenue for the whole year, that is
Let
from
him file his affidavit. Third learned counsel for party. Return of 4 weeks. Mr. P. Sharma represents all the respondents.
all,
As such notices are waived, extra copies be furnished within a period of 2 weeks from today. Respondents will file the necessary affidavit if so advised in the meantime, placed after returnability.
4 weeks.
Lordship, the matter may be passed over for the time being.
Lordship, in this matter, petitioner was settled with fishery for 7 years, Lordship. In the meantime, some damages are caused to the fishery by flood and erosion, Lordship. For which petitioner submitted a representation, page 27, Lordship. And at this stage, I am praying for direction to consider or dispose of my representation, Lordship.
First, let him get instructions. What is the status of this
If not disposed,
representation?
of, Lordship, then can be disposed of.
So let him get instructions. What kind of an order is that? If not dispose of, dispose it of.
Huh.
Let him get instructions here. 21st.
That's
Third learned counsel for parties. Petitioner is agreed that the fishery which was settled in his favor suffered damage due to devastating flood, erosion, and accordingly he represented before the authorities for refixation of the yearly revenue on the basis of the reports from the revenue authorities. But no such steps have been carried out by the respondent authority. He submitted that his representation. What is the date of the representation?
24/1/25, Lord.
24/1.
Lordship.
That
They
remains
have
pending.
only prayed for the digging lordship. May I disturb, interrupt lordship? They have only prayed for digging lordship.
Whatever it may be, you get your
Digging
instructions
well.
on this representation. The representation has remained pending and accordingly being agreed, he has approached this court. Learned counsel, learned standing counsel, fisheries department is permitted to complete his instruction by the next returnable date.
AFDC lordship.
AFTC, counsel to the AFTC, is this matter on 21st. In order to enable the standing counsel to complete his instructions, sufficient extra copies be furnished within 2 working days. Similar order.
No, my lord, similar, not a case similar, my lord.
Ah.
I have served a copy, though my lord, standing counsel was not there in the High Court, my lord, for the ICICI Bank. I have served a copy on the branch, my lord. My question before your lordship is this:
So what is the amount standing in your account today?
today is, my lord, 53 lakhs on 15th March.
15 March. And what
My-
is the amount for
First-
which?
In first case, my lord, disputed amount is 4,107 only.
Ah.
Second is not mentioned, my lord. They have straightforward, the police station straightforward passed the order, block him for the 64 lakhs, my lord. That is there,
Where is that?
my lord. I want to say to your lordships. Page, my lord, 25, annexure 8, my lord. This is to inform you that you regarding the account issue you are facing from last few days. And also we received request letter for return region for account lien marked from your end on 29/3/2025, where we received below mentioned
They have
information.
mentioned 64 lakh.
My lord, state for the case is for 60, but disputed amount is not mentioned, my lord. Nothing is there,
It
my
may
lord.
be for 64 lakhs also.
My lord. No, it may be part 1,000, 10,000, 1 lakh, that may be there, my lord. Because I am a grocery dealer, my lord. This happens in Maharashtra, my lord. I am from Assam, my lord, Guwahati.
Who's for the bank?
Bank, my lord, I have served a copy on him, my lord, in the bank. On,
You undertake trustee service on the bank.
no, I have already served, my lord.
Then you file an affidavit here.
This is there, my lord.
File, you know the procedure, Mr.
My lord,
President.
I'll file then, my lord.
You file an
Then it may
compliance
come up
affidavit.
tomorrow, my lord, I'll file your affidavit.
No, but what orders are you asking for?
I am paying for, my lord, that some amount may be withheld, my lord.
What is that sum amount?
Well, in one case, 4,000, my lord. In another, no mention, my
No
lord.
mention. So,
My lord, so may I pay that 50,000, 60,000?
no. Why that amount? Why not?
My lord, because they cannot withhold the account.
No. The application at page 25 shows 64 lakhs.
Well, he said that,
Whether 64 lakhs is
well,
connected to your
my
account
lord,
or
no
not.
amount has come to me in my account, my lord. Nothing was mentioned. When it was happened, what is the case number, who has filed the case, my lord, nothing was mentioned, my lord.
Therefore, we want to hear the bank authority. Is
So
is there
so-
any counsel?
No, my lord, it is bank. I have served a copy on the bank, my lord.
Where is the branch? Which branch?
Branch is Fancy Bazaar branch, my lord. I have served on 27th, my lord, day before I started. That is why, because I am in urgency of the matter, that's why I have served a copy on him, my lord. There is no standing counsel for the ICICI Bank.
No, but without hearing the bank, what orders do you want
If
us
my
to
lord,
pass?
but I have already served on copy on him, my
You
lord.
have served, but
My lord.
we'll have to ensure that they appear before the court. If they don't appear, we'll have to pass.
It will come
strictures.
tomorrow, my lord, I'll file a photocopy of, I'll file this supported by affidavit, my lord. Because next, my lord, Review vacation is coming, my lord.
No,
for
no,
10 days,
view vacation is coming is all right.
my lord.
What orders do you want from the court? That
I want
that
that,
amount should
my lord,
be
some
your
amount,
account.
maybe, some amount
What,
maybe
what is the
dropped,
sum
my lord,
amount?
and remaining
What
maybe
is the
allowed.
sum amount?
My lord, what, it is up to lordship, my lord, 1 lakh, 2
No, why
lakh.
should it be? Because we have not asked for freezing of your account. We have to find out what is the status of this matter, why 64 lakhs have been found to be,
Then bank,
is the
it
amount.
was at the instance of the, my lord, police station, Maharashtra, my lord.
That's right, but the bank will have to give us this information. That is why we want the
The
bank.
bank, this letter was written by the bank, my lord. Bank to us. When we question how you have withheld that, this why this lien mark has been put, then they have supplied this
Heard
letter.
Mr. A.K. Maheshwari, learned counsel for the petitioner. The petitioner is aggrieved by the actions of the ICICI Fancy Bazaar branch bank. ICICI Bank Fancy Bazaar branch in freezing the current account number so and so, which the petitioner claims he uses for his business purposes. So, petitioner claims to be he is a what?
My lord, grocery business,
Grocery dealer.
grocery wholesaler.
Grocery wholesale owner, wholesale dealer. He therefore uses his account for making payments towards his business commitments. So, however, since which date was it freezed?
15th March, man.
Huh?
15th March.
With effect from 15th of March, this account was free and the petitioner is unable to operate the bank account. So, learned counsel for the petitioner submit that the bank has intimated the petitioner that this is on the request of communication received from Cyber Police Station, Navi Mumbai.
But there are two communications there, madam. It is second. First is, my lord, page 21, where it was mentioned 2,45,000, madam. But verbally they have informed that only
Cyber
4,100,
Crime Police Station in Thrissur city.
my lord.
Where the transaction amount in respect of the petitioner's account, which is involved in fraudulent transaction, is shown to be to the extent of rupees 2,45,574. This is the amount.
Oh, yes.
Subsequently, the bank received another communication from the Cyber Police Station, Navi Mumbai, investigating CR number 83 of 2024, requesting the bank to freeze the account bearing the number which is currently held by the petitioner and view of a disputed amount shown to have been fraudulently transacted to the tune of 64 lakhs. So, in view of these two communications, the bank has freezed the account, current account of the petition. So, petitioner is therefore before the court praying for appropriate orders. Considering the hardship expressed by the petitioner, we permit the petitioner to serve a copy of the writ petition along with a copy of this order by way of dusty on the bank authority and file a copy of file a compliance affidavit by tomorrow. Matter be listed again on Friday.
My
List accordingly.
much better.
The walk out of the petitioner matter was found to be fake one. And police CM Vigilance is investigating the matter. And we have found out that the 20 numbers of such orders were found to be fake one. And thereafter speaking orders are passed. Not to be allowed, not to be posted after 2 weeks. In the meantime, the speaking order will be passed.
Speaking order has already been passed, my lord. That
But he
order may be closed.
You have the speaking order. I don't have it.
You have the speaking order.
Yes, my lord. I have speaking order.
You have it.
So, contempt,
But
Take contempt may be closed, my lord. I will challenge this speaking order.
you give us a copy of
Yes,
that
my
order.
lord. Yes.
Yes.
Heard learned counsel for the parties. This petition is directed alleging the disobedience of the order dated 4/2/2022 passed in WPC 654/2022. So the the
Okay, yeah, that's one.
contempt petition is filed alleging that the directions contained were not complied with by the respondent or parent. Today, when the matter is called up, counsel for the petition submits direction. In terms of the direction issued, the respondent authority has passed an order dated 5th of February 2025. By the said order, the claims of the petitioner were not found to be genuine and thereby rejected. So, copy of the order is placed before the court and is kept in the case of court. Considering that the order has the directions contained in the order dated so and so passed in the have been complied with, and the order, consequential order dated 5th of February 2025 has been passed. The court does not wish to proceed any further in the contempt proceeding. The same therefore stands closed. Notice is issued, stands withdrawn.
Item 8 also same, my lord.
Item
Item
Eight.
8. Yes.
same order,
Same, no, my lord. What I-
Lordship, here I have the speaking order. Similar issue.
similar order. Give us a copy of that order.
Okay.
Order get assigned. Who may do it?
Here, Lordship, I am appearing for the respondent.
Mr. B. Chaudhary for respondent in number 8, Mr. S. Thora.
No, 9 I am praying for. Till it's time to file my affidavit. Take note.
It's a SOPD format.
I am praying for the respondent 1 and 2, my lord. For 2, I will file my affidavit, my lord. Also allow me 3 weeks time.
Yes, Mr. Boro.
Yes, let it come up.
Matter be listed after 3 weeks on the prayer of Mr. S. Thora, praying for filing necessary affidavit in the matter on behalf of
Respondent 2.
respondent 2,
Two.
newly impleted.
Newly
Newly impleted respondent. Prayer made is not objected to this matter 3 weeks.
But page number 6 is the order.
Yes.
The relevant part is page number 9.
Which order?
Page number 6, my lord, dated 23/8/23. Is the contempt. Relevant part, page number 9.
Yes. What is this?
We have communicated with the department.
As per last order, my lord, there is a last order for taking instruction regarding verification whether the petitioner is entitled
No,
for.
has the directions been carried out?
That's it. After we have communicated with the DDC, District Development Commissioner, for submission of verification of record.
Who is representing the district? Which department?
It is Panchayat and Rural Development.
So you communicated to whom?
DDC, District Development Commissioner.
Direction is to whom?
To the commissioner, my lord.
Then?
Then we communicate with the,
No, your communication doesn't help. There's a direction to comply, you comply with it.
but submit verification report, they not submit.
So if they don't submit, you go to civil prison, wait there until the report is submitted. There is a direction to the commissioner to comply. If somebody has not complied under you, it is for you to decide what to do. But as far as the order of the court is concerned, it is not complied. If it is not complied, you are guilty of contempt.
But after court order, we have already communicated.
Very well, then we'll issue notice for contempt. This order has not been complied with.
Lordship,
Do you understand the implication of an order?
Lordship,
It has to be complied.
Lordship.
Merely submitting a communication to some officer, not doing it, if you are saying that you are powerless to do it, then you file necessary application seeking modification.
And that is after more than 1 year, my lord, of the order.
What do you want to do?
Lordship, kindly,
You want him to go to jail.
Lordship, kindly, 2 weeks time may be granted.
So a lot of time has been granted, but your officers are not realizing the consequences of this order. There is a direction to carry out.
Lordship,
Why that order has not been carried out? What steps have you taken? Have you prayed for enlargement of asking for more time for compliance?
neither verification will not pay the amount. Neither verification report,
I can't hear you. You have to be louder.
because Lordship, we have communicated that the
Have you read the order? Do you have a copy of that order of the High Court?
From the petition, page 6.
You don't have a copy of the petition.
Lordship,
Come to page number 9. Read para number 5.
My lord, the earlier they had filed an affidavit, my lord, on record, and that affidavit, my lord, nothing is there regarding the, my lord, compliance of the order, my lord.
Who is your senior standing counsel? Is there a senior standing counsel?
Lordship,
Who is he or she?
cake word, senior.
Please call him.
Today, he is unable.
He is not come to court.
Lordship,
Is he coming to court tomorrow?
Lordship,
All right. We'll keep it for tomorrow. Please call him.
Lordship.
Matter be listed tomorrow. Mr. K. Kumar, Additional Advocate General, is required to represent the department. Is requested to represent the department and apprise the court. Copy of this order be marked to the office of the Standing Council, PNRD department, as well as the office of the Senior Governor, Assam, for onward communication. Please ask him to come tomorrow.
Obliged.
Yes. This is for orders.
Yes.
Why is it for orders?
And Lordship, in fact, on the 18/3/2025, Lordship, there is an order by the court that so and so will understanding council to Health and Family Welfare for some time to produce the original record in which the decision to go for retender exam was taken.
And that photocopy I
Then-
have furnished him on the last occasion. Even I have provided to the other side.
Yes,
also.
yes. The-
My notes is there.
I want to read the next order. Next
What
order,
are you challenging here?
it is regarding the tender in the Dibrugarh Medical College, Lordship. And then there is a first tender, there is a second tender, there is a third tender. Now all these tender they are going cancelling because my client was the lowest bidder. So somehow they do not like my client. So now it is for the fourth time. Now they have decided to go for JAM. There is no, that is why it was the original record to be produced, the court said. On the last date, some photocopy of the minus was given. The record is not there. Because what in the record reflect, why, who has given the direction to sense these every time, Lordship? Only from this minus, nothing will come out. If the whole original record will come, because the word used is the original record. The court passed the order that the produce the original record. Because every time they have taken a decision to cancel the tender without any reason, man. Even Lordship, the photocopy of the minus is given, then it is in my favor, Lordship. There is nothing, Lordship. The Lordship can read this minus copy.
No, what is the stage of at what stage the interim order was issued?
Because they want to go for a fourth tender that time. Because I am the lowest in the third tender, so they have cancelled. Now they said they will go for a fourth tender in the JAM at that stage.
Interim order is bid document.
The bid document it is kept in evidence.
What is the bid document? Means the NIT itself.
Yes.
There is a fresh tender that was stated. Proceeding of the fresh tender was stated. There is the fourth tender.
Fourth
You have
tender.
been referring to the fourth tender. Well, decision is before the honorable court, my lord. Whether we are right or not, my their lordship will decide, my lord. Otherwise, my lord, this is the decision of the committee. That we will have to go for the lordship will see there is a bunch I have given, my lord. So it has been flag marked as NIT 1, 2, and 3. Or may I put
There is a photocopy bunch, Lordship. On the last date he has given a copy to me.
yes, that one, my lord.
This one.
Yes.
Yes.
Lordship may
So Lordship may please come to the number 1. It is on 26/10/23. This is the committee.
Yes.
They have said. And the name of the firm is there, Lordship, 1, 2, 3, all this. Then my client, yes, Lordship can see at page 2, the petitioner. In the top, number 1. All technical documents are found to be in order.
This is for the fourth tender.
No, it is first.
First tender.
I'll go one by one, Lordship, because what is the reason? Nothing, Lordship. In the number 1, all technical documents were found to be in order as per the tender norm, hence technically qualified. In my client, Lord. Then, after detailed discussion, as there is only one valid bidder, no comparison of rate could be made. So the committee has decided to suggest the principal come chief superintendent so-and-so, Dibrugarh for retendering. So, Lordship, the CBC is very clear, Lordship, it is clear, CBC is clear that if there are 2 tenders, 3 tenders, and out of them one has come out, you have to give it. the contract. This is not called one tenderer, Lordship, out of three tenderer,
No, the term used is one valid tender,
one valid
valid
tender,
bidder.
one valid bidder.
So it is possible that out of these three, these two were not even valid bidders.
Valid bidder. They were not valid bidders. So
Ah.
that is one, that is the first reason.
All right. Technically disqualified.
They're technically disqualified.
Okay, then
Then the second one. So accordingly, they said go for a retender. That is the first. Then the second one. That is at page 4, Lordship. On 26/12, 12:30. 1, 2, 3, 4 tenderer.
yes.
The committee members opened the tender, both online and offline mode, and found that 4 numbers of bidders were participated in the tender. The committee then scrutinized the technical bid document of the above bidder. After scrutiny, it was observed all the bidders as stated above has failed to submit, upload their bid document as per tender clause. So technically, they said that it was not uploaded in the year. And in view of the above, after detailed discussion, the committee has decided to suggest to the principal superintendent for retendering. It is the second.
Yes, then
Now the third on 12/2/24. All these farms are there. Their documents are here given. Then at page 9. Page 9. After scrutiny, all the bidders as stated above were found to be technically qualified as the tender was called for the third time. The committee members have decided to open the financial bid on 22/24 at 2 p.m. So, this is third. This is decided now. They will open. Suddenly, Lordship, now they have decided, page 11. They have not opened the financial bid. Now they have decided, since there are only 2 bidders participating in the process, to have a better participation and involvement of more members, bidders, to ensure the quality, committee members would like to recommend the principal come superintendent so-and-so to float a fresh tender through GEM portal now. And in my Lordship, there is a specific paragraph.
Paragraph it has more to more heavy size
Financial bid. So, Lordship, with all this has seen. In the third tender, Lordship, we have specifically mentioned in our affidavit that they have opened my financial bid.
your pleadings are complete here.
Yes.
All pleadings complete.
Yes, ma'am. So this is a decision, madam, whether we are right or not, madam, that is to be decided.
Lordship, may please come to page 111. The specific statement made. And that is why record is necessary, Lordship. Page 111.
Yes.
Line about 10 from the bottom. Therefore, the respondent number 4 and 5 in a most illegal and arbitrary manner invited fresh tender through GEM with a malafide intention to deprive the petitioner from awarding the contract in as the deponent came to know from the reliable source that 2 out of 3 members of the tender committee surreptitiously opened the financial bid of the petitioner and the performer respondent number 4, and it was found that the petitioner is the lowest bidder. Looking at this, Lordship, the original record was called for. And Lordship, this is very interesting, Lordship. Now the government stand in the affidavit. Government has filed an affidavit, Lordship, not an affidavit in opposition. but an affidavit, at least 2-page affidavit is there. Not para-wise, Lordship, nothing, but the government has taken a stand at least, Lordship. Now, Lordship, may it page 99. Lordship, may please come to page 99. Para 4. What is their stand? Let us see. The deponent further beg to submit that only 2 bidders participated after the third bidding. In the first tender bid, 3 bidders participated. However, in the second, 4 bidders participated. Further, the government of Assam filed office memorandum dated so-and-so made it mandatory for them for all procuring entities for procurement of goods and services that are available in JAM. Now, Lordship, that is their stand in the affidavit. In the memorandum, in the minutes, there is nothing like that, Lordship. That in view of this, they have decided and all that. If Lordship records come, Lordship can see that, that's a different matter, Lordship.
You
They
are
have-
saying that the fact that they have opened your financial bid will be
Yes.
available in the records.
Yes.
Online process.
Online,
The
the
online
tick will
process.
come, Lordship, let them,
Only
let
in the
them.
official record.
Records, online record, they'll have to do it.
No, they will give the online record, Lordship. Lordship can see, because immediately it's open, tick will come, Lordship.
Well, from 2019, the present petitioner is continuing. my lord,
So
this
what? I am the
supplying,
lowest
my lord.
bidder.
And my lord,
I'm
because of
continuing.
this, my lord, every time tender is my lord floated, there will be some my lord writ petition before the honorable court, and it continues, my lord. In fact, in the
So-
last occasion, for 2 years, my lord, the writ petition was pending. For some reason, my lord, it could not be concluded hearing. Twice, my lord, 2 judges, my lord, heard the matter. It was parted. One retired, then it was referred to another bench. It was.
No,
in fact,
so I'm arguing, Lordship.
No,
I'm not asking
yes.
for
So
time.
this is our decision. Lordship will decide, my lord. This is
Yes.
the decision.
Yes,
That,
then
my lord,
Lordship will decide.
yes.
I'll argue. my
Whether it is reasonable or
I'll
not,
argue
my
my
lord,
case.
is heard by Article 14, my lord. That is the
Yes,
issue, my lord.
yes, that I'll satisfy your Lordship. This is an arbitrary decision, Lordship.
Is the financial bid open?
No, my lord.
It's open, Lordship.
Because
Let them say,
well,
I'm on
it is
affidavit,
in
Lordship,
the-
and so. Let them bring the record.
No, what record?
Online, they will open here, Lordship. It's an online,
My lord,
online
if it is open,
tender,
my lord,
Lordship.
every bidder who is participated, they've got a key. They can see, my lord. Everything is there, my lord.
That is why I have said.
Then they can, my lord, download it and
Now
can
they have
press
closed it.
We will.
Immediately they cancel, they have closed the key.
From your side, you can view it.
No, that is why, Lordship, now
No,
let them open the key also.
There to see whether the
Let them open the key. I'll give a photocopy, I'll give a copy.
Then Lordship will post it on my lord immediately on reopening, because otherwise it will be difficult for them. Whether we can, because it is a my lord, third party who is to do this, my lord. It's not that the authority themselves. There is a platform, my lord, where the key procurements are made.
No. If see whether to go for a fresh tender for the third or the fourth time is one aspect of the matter.
My lord.
But while taking that decision, if you have opened the financial bid
Of course.
and
That
then you have
clarification,
taken a
yes, sir.
decision,
I will
then
file one, my lord, reply to whatever they have submitted, one short reply. to
And
that.
then open the key, Lordship, that online.
No, if we have not opened, then not open, we will make it
you
a statement on
give a
affidavit.
reply.
Yes,
and
and
then
if it is
produce the
open, then
relevant
we-
records.
And then, yes,
Yes,
Lordship, and
for the-
then Lordship, we have filed a specific affidavit before this court.
You give
They have
reply.
taken a stand. Lordship, may please come to page 113. Page 113. Page 113, Lordship, get it. This is an additional affidavit duty file. After our decision, Lordship, what they have said, that because of that memorandum, they have taken this decision to go for a jam tender. Mandatory. And now, Lordship, we have given all these, even the health department. This is not in jam. All this tender, I have annexed.
Lordship, so far as
This
well,
will
this
show,
I can
this
reply
will
to
show,
this.
Lordship.
I can reply
what-
for the inspector.
Yes. Let them give a reply.
Going
and
by,
come.
you don't have a grievance that they have floated the tender through GEM. There is no grievance on that.
That is my grievance, my lord.
Huh.
Yes, that is my grievance. They have decided to go first, second, third. Everywhere I'm
Not, that was not through GEM,
not through them. It is online. It was online.
but now they have decided to go through GEM.
My lord, on 8/1/24, the finance department issued a notification that henceforth all procurement will have to be under the GEM portal. On 9/1, this tender was issued. So, my lord, subsequently they say that we are going for GEM because 8/1 this has come up. But that is not part of the.
You get all these back. Why don't you file the proper affidavit?
Yes.
No, it is
yes.
there in affidavit. Affidavit in opposition, we have filed already. ma'am. It is there.
It is not evident in opposition.
Yeah, it is affidavit in opposition, my lord.
Give us that instruction as to whether the financial fees were open.
Hmm. There is nothing, not a whisper.
But that is in the reply they have said, not in the petition.
Very well. You show it to us.
My lord.
Get your instruction.
And lordship, this 10 taken, I'll satisfy lordship. They have to lay it before the
Mr.
They cannot go
Sharma,
like this. In the act itself, it is very clear
Mr. by Mr. A. Gautam,
how to go for.
the petitioner, and Mr. P. Gogoi, learned additional AD, assisted by Mr. M. Mia. The counsel for the petitioner submits that in terms of the earlier directions of this court,
Any date after 25th.
the petitioner, the respondents were required to produce the original records. Mr. Gogoi, on the other end, submits that the copies of the minutes
Yes, it's already on
of
record.
the
File on product.
tender bid opening meetings are placed before the court. Stop.
And copies have been served to the petitioner.
And copies thereof also have been served to the petition. Stop. The counsel for the petitioner, on the other end, submits that he has instructions to submit, which is brought on record by way of an additional affidavit.
No, in the reply, madam.
In the
Reply to affidavit of
reply affidavit that the steps for proceeding for the fresh tender through GEM was pursuant to opening of the financial bids submitted by the petitioner
in the third tender. madam.
in the third tender. So this submission is disputed by the counsel for the respondent. Accordingly, this court permits the
Two members
respondent
of the
counsel
committee, Lordship. I am very specific, Lordship.
No, I will
Two members is open.
to produce the relevant records to before the court on the next day to show as to whether the financial bids were open in the process of the third tender before calling for the fourth tender.
By two members, Lordship. Not one, two members. And they have to open the key only. I'll show here
No, two-member has
of the
opened,
committee.
has opened.
Yes,
Two-member, one-member tender committee has opened.
open.
Has
But
been
on-
opened or seen by the respondent authority.
On 6th, my lord.
Hmm?
My lord, immediately on the reopening, my lord, because it's regarding supply of dietary articles. It's pending for
Yes.
a long time.
23rd?
My lord, my senior has got some
I'll be out
difficulty
of
in the
station.
first-
21 to 25th, I'll be.
On 29th, my lord.
29.
Yeah.
So let it be on 30. 30.
That will be a miscellaneous day, my lord, whether hearing need to.
No, we
It
don't know
may not
hearing
be
or
this
not.
when
If
it may
it
be
start,
another.
it start.
Let it be on a hearing day, at least we can
Hearing day, all
conclude
right,
it. Yeah.
29.
29, my lord.
29.
Oh, like,
List on 29th of April.
Interim order will continue.
Interim order passed earlier will continue. Basic law, probably. No steps on respondent
My lord,
5.
I have taken justice service yesterday, my lord. I am filing affidavit on justice service tomorrow.
But
by
you have to
tomorrow.
take by registered post also.
Yeah, I have taken.
You have taken. Office note dated 7/4/2025 reflects that steps on respondent 5 by registered post was not taken, although notice by way of trustee was issued, but no affidavit was filed. Where a counsel for the petitioner submits that he has undertaken steps by registered post AD along with Dusty Service and has also filed the affidavit.
By tomorrow I will be filing.
And will also file the necessary affidavit. Matter be posted after 3 weeks.
My lord, kindly
Registry to
it did
make
make
necessary endorsement.
it did make kindly please, my lord. Because a
Are you
contextual
not taken steps? What is this?
my lord,
And you want to fix it?
the only matter of filing my affidavit, it is there.
It's not a matter of filing affidavit. You have to take steps by registered post. On 7th, when did you take registered post?
My lord,
When did you take steps?
by 7th, my lord, on 7th.
So 7th,
Earlier it was usual post, subsequently, my lord, it was more rectified, my lord, registered post.
let it come on 2nd of May. 2nd May,
My lord, what is going on that is
then 30,
my
30 April.
apply.
May I please your lordship, lordship, my senior Mr. P. Mompes lacks in another court. Lordship, may kindly pass over the matter for time being.
My lord.
Why is it for order?
Here, my lord, I am appearing on behalf of National High Authority of India, my lord.
Service report is awaited.
Lordship, we just yesterday filed our wakalat number, so I'm not much aware, lordship.
And
Timing.
I
Evening.
also pray for some time because I have sent for meeting. And lordship time.
None appears for the parties going to hold. Matter stands passed over. Huh? Yeah, Mariri Golo Peter. Mariri.
My lord, I saw you. This is item number 13.
You are here, but your counterpart is.
My lord, I was in lakes, my lord, it is a problem. But otherwise, well, I am newly entered, my lord, in this case. And the interim order shall continue and let them file your affidavit, my lord.
All right, matter be listed after 2 weeks. Yes, Mr. Borwa, we are
My lord,
deferring it for 2 weeks.
But because I have sent for vetting, it is to come from Delhi.
2 weeks or 3 weeks?
After 2 weeks, my lord.
2 weeks. Matter be deferred, be listed after 2 weeks.
And
Joint request made by counsel for the party. Yes.
Well, the interim order shall continue and my name may be reflected in
Interim
it.
order, if any, will continue. Names of Mr. P. Monto be reflected in the cause list as a counsel for the petitioner.
And
Yes.
another, there also, but I have filed one IA. That may be my lord listed along with.
I have not.
Yesterday I have filed.
But I have not issued copy.
Yesterday I served.
You will make a mention.
Okay, my lord.
Separately, yes.
Not copy.
SK Medic.
SK.
SK Medic. Yeah,
Awesome.
And service report also may be waited, my lord.
Awesome.
I'm so sorry, my lord. I'm sorry, my lord.
You have to be sorry for
Sometimes it clashes, that's all. And all preference we given to all the courts. Sometimes I feel very bad and embarrassing in front of.
that is the charm. That is the charm of being in practice.
No, I remember one senior counsel used
To
to
be
say.
visible in one court and be invisible in other courts. So no problem.
Hello,
This busier the council, healthier is the bar. Yes.
Sometimes it feel difficult. One senior counsel used to tell me that all courts are equally important. Don't say that I am in that court, in that court. All courts are equally important. Sometimes the CGM courts are also equally important.
Yes, yes.
District courts are equally
Yes,
important.
yes. All courts are courts.
Courts, all courts.
I feel sometimes very embarrassing to just attending in some.
That's the advantage of a senior counsel. You can appear and disappear whenever you want.
Disappear is not here. Disappear.
Unlike,
Disappear.
unlike the advocates on record, they can't disappear.
Disappear, you can do it in Supreme Court, in some other court, because all briefs are interested and they take away. That's the best part.
It's permissible. It should be permissible here also, subject to what the bar has to say.
Yes, yes, of course.
Yes.
My lord, this is a very small issue in crust of the matter. Is, my lord, my privity of contract with NHIDC. There is a, my lord, the government acquiring authority is the state. Now requiring authority is the NHIDCL for construction of improvement of 2-way to 4-way lane. That's Manja side road. Now, accordingly, my lord, the contract was entered in the NHIDCL and I am a contractor. Now, what has happened, my lord? The work is completed. Absolutely, there is no problem. Compliance certificate is given. After that, they have issued a notice to NHIDCL to me saying that a forest royalty has to be paid. That's the issue in it. Whether for art, removing art, which is not from the outside the area, not from the forest, neither from a mining lease. I am not entered into any mining lease. So whether a royalty can be imposed on an art where, my lord, the right of way was given and I have dig it from that area, that art itself. I have not brought from outside. Neither my bill which has been submitted, it is not on a basis of commercial where I have asked for claiming it against the art. It is a total as a whole I have art. It is not a separate bill was given that so and so for art you have to pay me. Then it will be a commercial. So my respectful submission is that one, the forest department cannot issue a notice to me saying that royalty has to be paid. They have to issue to the NHIDC, which accordingly kindly see me, they have replied also. My impugn order, kindly see my letter, impugn notice is at page 42, my lord, first. Kindly see 42. 42, my lord. Request for payment of outstanding government forest royalty and other taxes against project estimated requirement balance for it to be paid in connection of so and so. With reference to subject side above, you are hereby requested to deposit outstanding government forest royalty at page 42, my lord.
Yes.
1812. With reference to subject side, you are requested deposit outstanding government forest royalty, other taxes against project, estimated requirement, balance quantity to be paid in connection with so and so. In this connection, I request you to kindly deposit balance government forest royalty, other taxes as soon as possible. Therefore, I request you to take necessary action. So, if your lordship see the royalty which they have sought for is art. We are on art. Art is that if you see balance royalty amount to be paid is 2 crores 0290.068. Lordship, what is the figure? Now, we have given a reply at page 43. Page 39. 39, before that, 39 is reply by NSL to the forest at page 40. At page 39 is reply to the meeting. There was a meeting which has been held at page 39 because the minutes of meeting was held, and accordingly at page 39 reply was given on 8 October. Your kind attention to hereby invited to a statement cited above, wherein balance forest royalty payable for art of so and so has been shown as so and so. In this connection, it is to be stated, art required for execution of project was obtained from cutting of the high level areas within the right of way, purchased and handed over to the contractor by NHIDCL. The quantity of art obtained from such cutting was sufficient to meet the art filling requirement of the project. Hence, no art was borrowed from any quarry outside the right of way. At 41, we clarified at page 41. NSIDC has clarified at page 41. If your lordship looks at page 41, they clarified at page 41. With reference to subject so and so, letter dated so and so, second paragraph. In this regard, it is pertinent to mention right of way have acquired for widening from existing 2-lane to 4-lane to remove the black spot and accident prone areas plan horizontal and profile vertical have suitably been designed for suitable curvature and granite for the road as design speed. As the existing road consisted of lot of curves and granites, art mass, including rock portion, was dug up, removed. Moreover, there was no much disposal location in the project. Removed art and rock spell were utilized in cut and fill method as eco-friendly measures. Therefore, the quantity of the art taken from right of way and utilized with right of way may kindly be considered for waiver of forest royalty of minor minerals. This was cleared by NHADCL. But their privity of contract is with them. If something has to be done, they can do against the forest, against the NHADCL, not against the contractor. It's a direct privity of contract with them. So our whole case is that
the question of whether forest royalty is required to be paid, I think, was being considered in a division bench.
Yes, that is a case of Muslim Ali, my lord. That whether forest royalty can be paid or not. That the court said that it has to be within the contract. You cannot go outside the contract.
No, whether forest department is entitled to
Forest
collect the royalty for the soil.
That was a contract between the PWD and the contractor. The forest department say royalty has to be paid. In that case, I was the senior counsel there. Appeared against state has filed. We have there was a writ petition which they allowed in our favor. PWD has preferred an appeal against that order, writ appeal, which has been favored, which they have gone. So the issue where whether the royalty has to be paid by the contractor. Royalty has to be paid. Now the court said the royalty doesn't have to pay the contractor. You have to go by the privity of the contract. What the contract says. Now if you charge, where is the charging section? Number one, if you pay royalty, that means it amounts to double taxation. Now, my lord, for example, I being a contractor, now the stamp is required, then stone is required. I buy from an outside source. That doesn't mean the forest will charge me royalty because already that particular source has already paid tax and I am buying from that particular source.
What do you say, Mr. Lutia? You are appearing for?
My lord, I am appearing for my lord.
Karbi Anglong.
Karbi Anglong, response number 23228.
So, including forest.
Forest, my lord. My lord, lordship will look into page 16, paragraph 13.
16.
Page 16, paragraph 13. My lord, second line, my lord. 1, 2, 3, 4, 5, 6 line, my lord. It is to be stated that no art was excavated or carried from outside to the site of the project work. As stated here, art was removed or dug up from the land handed over by NHADCL to the petitioner company. The art which was dug up was utilized in cut and fill method, which is eco-friendly, and there was no marked disposal location at the project site. My lord, petitioner earlier, my lord, approached this honorable, my lord. The petitioner earlier approached this honorable court when we enhanced the forest royalty. What are the statements made in the earlier petition, my lord? In the petitioner has not disclosed anything about the earlier petition, my lord. What they have stated in the earlier petition, that is a petition number 3264 of 2023. The statements made in the present petition completely contradictory the statements made in the earlier petition. In the earlier petition, they have stated that they had taken the, my lord, specific, they have stated that they took the permits and they collected the art from outside. If they're taking the outside from the art, they are liable to pay the royalty. But they have not enclosed the contract agreement. In the contract agreement itself, there is a clause of payment of forest royalty, and they have not disclosed this in the present petition, my lord. And the particular petition is 3264/2023. And I'm reading from that particular petition, my lord. What are the statements they have made?
It is not included here.
Not included. They have not disclosed anything that they have filed the earlier petition. And what are the statements they have made in the earlier petition? They have made the.
So let us issue notice first today. We'll issue notice at this stage.
My lord.
You get your instructions and bring it on record, whatever you have to say.
Lordship, I record my statements that the petitioner has not disclosed anything about the writ petition filed earlier and the statements made in the earlier writ petition.
Heard. Mr. D. Das, Learned Senior Counsel, is seconded by Mr. R. Sharma. Petitioner is aggrieved by the demand of for payment of forest royalty by the respondent authority in respect of works which were undertaken by the petitioner with the National Highway Authority. Which authority you've undertaken the work?
NSIDCL.
NHIDCL. Stop. Learned Counsel for the petitioner submits that the respondents cannot demand the forest royalty, cannot demand for recovery of forest royalty from the petitioner as the as they're not authorized under law to do so. Further, these the royalties demanded in respect of soil which is being dug up while construction of the national highway. Stop. The portion of the land from where the soil is dug up is in the right of way and is outside the forest area, declared forest area. Is outside the declared forest area.
Please, I'm sorry, madam.
The soil is out, the road is
Yes.
outside the declared forest
Yes.
area. Therefore submits that there is no occasion for the
Only
respondent authority to demand forest royalty to be paid by the petitioner as the soil was not excavated from within the forest area.
But our submission is that NHADCL becomes the repairing authority and it is their property. And we have dug
Further,
within the area belonging to right of way.
further, it is the NHIDCL which have been given the right of way, who has issued a tender, who has issued the tender for construction of the road, which was ultimately settled with the writ petitioner. Stop. The petitioner executed its work only in respect of the, what is that, right of way?
Right of way.
Right of way. And not in the forest area, declared forest area. So he is therefore submitted that the demand made from the petitioner is unjust and the same should therefore be set aside and quashed. There are, per contra, Mr. K. Sukia, standing counsel, appearing for all the respondents.
Not all the content. I am filling for my lord, phone number
2, 3, 4, 5, 6.
my lord.
2, 3,
Forest
4, 5,
officer.
4, 5, 6. And Mr. S.R. Borua for number 1, Forest.
Forest.
Who is there? Mr. S.R. Borua, Learned Government Advocate, appears for respondent number 1. Stop. Mr. Sudia strongly objects to the submission made by the petitioner. It is submitted that the petitioner had earlier approached this court by filing WPC number
And I have already given the copy, my lord.
3264
3264 of 2023.
2023.
And the specific statement was made in the writ petition in paragraph 8 to the extent that as and when required, the petitioner would extract stone and earth from the forest land under the KAC after receiving permits and depositing the applicable royalty and fees. But petitioner has not disclosed anything about that.
There was in the state writ petition filed earlier by the petitioner, there is a clear averment that as and when required, the petitioner will extract stones and sand from the forest area after getting necessary clearance from the Karbi Anglong Autonomous Council. So, Mr. therefore submits that this statement
Made in the present
that the statements made earlier in the writ petition which came to be This writ petition is pending or disposal?
My lord, they have, they have withdrawn it as infractions. It is enhancement of forest royalty. That's
This
all.
writ petition, earlier writ petition was filed challenging the enhancement of forest royalty. And the statements made therein are completely contrary to the statements made in the present writ petition. And there is no averment that to that effect. Stop accordingly. This writ petition should be dismissed at the threshold on the ground of suppression of material facts. That's your submission?
Well, I'll just make one particular submission to what my learned friend has just said. My learned friend was reading that paragraph. As and when necessary, we'll pay the royalty of art. So if you see at page 46, if you see 46,
yes,
which is addressed to us also, kindly see there are three divisions which they have made. One is sand, one is art, and one is stone. So there is no dispute regarding the stone and regarding the sand. But so far as art is concerned, as and when necessary, we'll pay. Now my lord, it has now.
No, we are only recording the submission.
Yes, no,
which is
I'm
made.
just telling your lordship that he's saying that is only as and when necessary. There is no dispute about stone and sand. That is already we are paying royalty.
Now, other statements are also there.
There is,
The council, without any objections, continue to receive the same and allow the petitioner permits to extract art and stone as was required.
We'll see.
The council for the Karpi Anglong submits that there are clear averments that in the earlier writ petition that the petitioner had that there was a requirement of extracting stone and earth from the forest area as and when required. Stop.
Forest area as council land. Both are the council land.
Mr. Das, on the other hand, reiterates his submission and further makes his submission before the court that in the earlier writ petition, the averment made was extracting requirement for extraction of stone and earth, if required.
Yes.
As and when required. Stop. And therefore, there is no suppression of fact. And this reference to the earlier writ petition was not made in the present proceedings as the issues are completely different. So, having heard counsel for the party, at this stage, this court is of the view that notice can be issued. Stop. Issue notice returnable 4 weeks since Mr. J. Sutia represents the respondents have 2, 3, 4, 5, 6 notices are waived. Extra copies be furnished within a period of 1 week from today. Mr. S.R. Borua for respondent number 1.
Forest.
We don't know, you're a government advocate. Are you a government advocate? Yes. So you can appear. Maybe, but you're a government advocate, you represent department. If the standing council is not there, what can be done? Mr. S.R. Borua represents the respondent number 1. Stop. Matter be listed after 3 weeks, enabling the respondents to complete their instructions and file necessary affidavit. Meanwhile, no coercive action be taken against the petition till the next returnable date. List again.
Can it be listed on 3 to that particular petition, madam?
That you said it was withdrawn.
Withdrawn, my lord, but the statements which they have
Bring it on record if required. So already withdrawn, why should we get it done? This is matter again on 5th of May.
5th of April.
My please, Your Lordship. Your Lordship, this matter has become infractuous, so I may be allowed to withdraw with regard to file a fresh.
Mr. M. Amir.
I.H. Nasil.
I.H. Law Court. Counsel for the petitioner on instruction submits that the writ petition has become infractuous and he prays for liberty to withdraw the writ petition and file it afresh if so required. MS
Chief Oral also appearing on behalf of
Chief
S.
Bra
Dutta.
appears for the Panchayat and Rural Development Department. Writ petition stands dismissed on withdrawal with liberty. Interim orders, if any, stand vacated. Pending ayes are also dismissed.
Valuable.
May it be proceed. My lord, the I is for rectification of the order.
Correction where?
My lord, the relevant page is 10, my lord. The bottom line, page 10 of the application.
Yes.
The bottom line, the sentence starts with the interim order dated 31/1, my lord. It may be rectified to the effect that the impugned order dated 31/1/25 insofar as it relates to the writ petitioner whose name appears as serial number 18110 well remains stay till such speaking order as directed is passed by the respondent, my lord. This is the-
Oh, sorry, I didn't get you. You're reading last line in page number 10.
My lord, my lord.
Yes.
It starts with the interim order, my lord.
Yes.
It may be rectified to the effect that the impugned order. This is the 31/1/25 is the impugned order, my lord.
Okay.
It may be rectified to the effect that the impugned order dated 31/1/25 insofar as it relates to the writ petitioner whose name appears as serial number 1810 well remains stay, my lord, till in place of continue, my lord. This is not. This is not.
Who's for the respondent? Any objection?
I'm appearing on behalf. He paid to it.
There's a correction in the order.
Yes, your lord.
Heard counsel for parties. This IA is filed seeking correction of the order dated
28.
28/3/2025, passed in WPC 1239 of 2025. In the said order, by the said on the said date, the order was passed by closing the matter and permitting the petitioner to file an application before respondent number 2 with all particulars. And the respondent 2 thereafter will examine the matter in the light of office memorandum dated 2/2/2024. In the said order, there was an interim order passed till the speaking order is directed by the respondent, where required to be passed in terms of the directions of the court. So, however, this direction of the court, as it appears now, requires correction, and accordingly, it is directed that the impugned order accordingly, it is directed that in place of, write this line, underline, in place of so and so, the following shall be read. The impugned order dated 31/1/2025, insofar as it relates to the writ petitioner, whose name appears as serial number 1810, shall remain stayed till such speaking order as directed is passed by the respondents. So, this order passed in the IA today shall be read together with the order dated 28/3/2025 passed in WP6. IA accordingly stands allowed.
Obliged.
The rest of the directions contained in the order dated so passed in WP6 shall remain the same.
Obliged.
Now, Mr. Pegu for CGC. immediately take over.
Lordship, this is an arbitration petition preferred under section 11(6) of the Arbitration and Conciliation Act, Lordship. Notice was issued on 6/1/2025, Lordship, and steps are complete.
I'm appearing for the sole respondent, my lord. I request some time to file my response on that, my lord.
Ms. U. Sharma for the petitioner, Mr. M.S. A. Gayon, learned CGC, appearing for the respondents. Submits that, how much time you require?
My lord, 3 weeks, my lord. 3 weeks, my.
Prays for 3 weeks' time to file her objections. Prayer made is not objected to placed after 3 weeks.
Lordship, a fixed date may be given, Lordship.
Fixed date. All right. 7th of May.
Lordship. Highly obliged.
Must oblige.
My lord, I am appearing on behalf of Sheikh Mukhtar, my lord. But for which time may be granted for filing affidavit, my lord?
3 weeks, Lordship. 3 weeks, Lordship.
Lord. 3 weeks,
Appointment
my
to
lord.
arbitrator.
3 weeks, my lord.
3 weeks. Counsel representing the Mr. S. Dekha for the petitioner. Prayer is made on behalf of Mr. S. K. Mukhtar that 3 weeks' time be granted to file the objections. Prayer made is not objected to list after 3 weeks.
Lordship, date may be fixed.
7th May.
7.
It's on 7th May.
In respect to item number 17, 18, and 19, Lordship, similar matter is posted on 28/4/25, Lordship, whereby Lordship is directed us to obtain instruction from the Deputy Commissioner. So, my lord may take with the matter on that.
Yes.
It is submitted at the bar that similar matters are posted on 28/4.
Lordship.
Accordingly, this matter be
In
listed along with
WPC, my lord.
WPC
WPC 1081
1081
oblique 2024.
of 2024. Similar orders for item number
18 and 19 also, Lordship.
18 and 19.
19 also.
17, 18, 19.
17, 18, 19.
In the meantime, my lord, my friend will take inspection.
I will.
List on 25th along with.
All right, Lord.
I will yes.
Yeah, please, Lord. This case relates to the non-payment of higher charge, my lord. State has the filed affidavit, my lord, admitting the contention, my lord. Verified, they said, my lord, it has been sent for.
On the basis of paragraph 5, my lord may dispose of.
Paragraph 5.
Paragraph 5 of our affidavit, Lord.
Page 44.
Paragraph 5, Lordship, cert is also given over here.
Heard learned counsel for the petitioner, as well as Mr. K. Gogoi, counsel appearing to the respondent. Petitioner is agreed by non-payment of bills in respect of higher charges by the respondent, amounting to 15,81,181 against vehicle number AS 09 capital C 4910. Where the respondents have filed an affidavit where there is a clear averment that the petitioner is entitled, clear averment that para 4 onwards that the petitioner is entitled to be paid the amount of rupees 15,81,180. Stop. The said amount are put up for sanction of fund by way of 2 proposals. Stop by proposal number 5185 hyphen 5199 within bracket RB dated 13/9/2024 amount of rupees, total amount of rupees 15,23,786 is being put up. This is one proposal or two? Each proposal for each
Lordship,
particular period.
proposal, there are two proposals, Lordship. Proposal one proposal is 5189 to 5199, Lordship. It is in respect of the, that period is specific, chart is there, Lordship.
No, what I'm saying is,
Two proposals.
are these two proposals or these proposals are put up in two lots, but proposal one contains.
Proposal one contains in respect of the debt period, Lordship, and next one is, Lordship,
All right.
for that period. That
And
month,
proposal number 5217 RV dated 2009-2024 for an amount of rupees 57,396. So it is there is an averment in the affidavit that as soon as the sanction and allotment of the fund against each of the proposal is received by the sanctioning authority, required steps will be credited to the bank account of the writ petition. Stop. In view of the averments made and the submissions made by the council, this court is of the view that the writ petition can be closed with a direction to the respondent to ensure that the proposals put up are duly sanctioned and the funds as and when received are credited to the bank account of the writ petition.
Within a period of month.
With the above observation, the writ petition stands closed. Now, it is expected that the claim of the writ petitioner should be settled within as expeditiously as possible within the outer limit of
4 months. 4 months.
4 months.
4 months. In a period of 4 months will clear. Otherwise, Lordship, he has to come again, Lordship.
Within a period of 120 days from the date of receipt of a certified copy of this.
Lordship, in this case, I have received instructions from Lordship may give 2 weeks time. I will file affidavit, Lordship.
Mr. Borthakur for the petitioner, Mr. K. Gogoi, counsel, additional senior government. You are additional senior government.
Lordship.
Is allowed. Is allowed further 3 weeks time.
2 weeks time.
2 weeks time. It is instruction. Please take it after 2 weeks.
May I pray for a date, my lord? Any date in the first week of May?
First week of May. All right, 5th of May.
Lordship. Oblige, Lord.
So it's a pending bill for hire surge of vehicles, pending since 2019. So my learned friend, he has to file affidavit in opposition.
The petitioner submitted that will file an IA for remove. The petitioners have submitted that on the last date that they'll file an IA for removing the name of transport.
I'll file also within 1 week. Because transport is not transport is not a necessary party. So I will file one IA for removing their name from the cause list. Transport department. I don't have any grievance against transport department. So ultimately, I will file one IA lordship.
We can record your submission if you want.
Yes, within 1 week lordship.
Right. Counsel for the petitioner prays for a week's time.
And lordship,
file
my
an
learned
IA
friend, he will file affidavit in
or
opposition.
striking out the name of the transport department. Meanwhile, the respondent authorities.
But already we have received communication from the authority as the bill amounts, the amount of the bill is amount to more than 8 crores. There needs some further time for verification.
We'll file the necessary affidavit within a period of 3 weeks. 3 weeks from today.
Kindly lordship fix a date. Lordship.
But you are filing an IA, you file the IA first.
Within 1 week I will file.
So moment you file it, then you get the date fixed.
Lordship, I am of that.
Public.
Yes.
I received my instruction, lordship. It's in the first week of May. In the meantime, I will file my affidavit.
Mr. Kakoti appears for the petitioner, Mr. S. Bora, that is now the DMD, submits that he would like to, he prays for further 2 weeks.
2 weeks. Not 3 weeks, let it be on 5th of May, my lord. I will
3
file my
weeks time to file to complete his instructions and file necessary affidavit. Place this matter on 5th of May.
Lordship, interim may continue.
Interim orders, if any, shall continue till the next date of this.
Obliged. Hold on. In this matter, we were supposed to file an affidavit. Almost ready, my lord. We'll need a week, 10 days time for that. In any case, my lord, there are two connected writ petitions which are fixed on 28th. So, those matters are already fixed.
So you want this matter to be listed on 28th?
Yes,
Along with
Lordship. Lordship, if he files it before by Bihu vacation or immediately
By
after,
Bihu,
you can't.
difficult.
Immediately after, we can file a response also. If he files on, we reopen, I don't know when, on the 28th,
Except
21st.
judges, nobody wants to work in Bihu. So
No,
don't expect,
he has finished his part.
don't
He has
expect
finished his part
affidavits to be filed after Bihu.
on the 21st. Lordship. And I can respond.
21st is
Holiday.
I
Is the
perhaps will not even get back.
21st is not a holiday.
Okay, Lordship, they let him file by the 28th. We'll take a call
The lordship will simply fix it along with the other two matters.
on the 28th.
On 28th, we'll file it in the meeting.
28th.
Yes, of April.
Right. It is submitted at the bar that there are two other writ petitions which are fixed on 28th of April. What are the numbers?
6299 of 24
Yes,
and 1604 of 25.
1604 of 25. Let this writ petition be also listed along with these two writ petitions on 28th. Stop the respondents meanwhile. We'll ensure. We'll attempt to file their affidavits.
No, Lordship, ensure. Not attempt, ensure. Because I don't have a
Let it
stay
not be
order.
on record, but we'll definitely file.
Because I don't have a stay order and it's hampering my business.
All right.
Or otherwise, let me get a stay order of the termination, of the suspension.
We'll endeavor to file the affidavit.
Lordship, it's too soft. Too mild. Something stronger. They're very strong people.
No, it's all right. They have given an undertaking, they'll file.
We'll definitely file.
And you are entitled to press for an interim order on the next day.
Yes. Lordship, that may be put on record.
If the affidavit
In one, it has been vacated.
No, but the second
And
one,
in the other two, interim was considered and rejected.
no, the other one interim was
all
not
right,
done.
we'll put that on the next date if the affidavit is not on record.
Mild.
Definitely.
Obliged. Lordship, in this matter, we have filed an IA for withdrawing this application, Lordship.
For
withdrawing this instant case.
You have filed an IA?
Yes, Lordship.
Where is the IA?
Today we have filed before few hours, Your Lordship. So,
Let it be tomorrow.
Obliged.
The IA file করতে People keep a IA file. Get the IA listed tomorrow. Matter be listed along with the IA stated to have been filed by the writ petition.
In this case, Malak, further 3 weeks time may be granted to file rejoinder affidavit. Respondent filed Malak affidavit in opposition.
They are objecting.
Malak.
Yes, Mr. Goswami.
No, I filed our affidavit and for content
Mr.
of nothing remains, my
Patgiri
lord.
prays for further 3 weeks time to file
Recently ended.
his reply affidavit to the affidavit filed by the respondents. Mr. U.K. Goswami, CGC appears for the respondent authority. List again after 3 weeks.
Obliged. Date may be fixed, Malak.
After 3, you pray for it. Update.
May I please? My lord, on payment of contractor's bill, my lord, My lord, for the same work, my lord, for the same year, my lord, 4 other repetitions were disposed of, my lord. My lord, these are the orders, my lord.
Lordship, it may be disposed of.
Admitted. Admitted amount.
No, Lordship, it may verify and
Verified.
Verify and dispose of. This is the order.
only thing, Lordship, the time limit if is given maybe fixed 6 months. Lordship.
Just
6 months.
It is 3 months given, my
Giving
lord.
a time limit.
3 months given, my lord.
Because Lordship, now rainy season will come and our staff will be busy in all that work. Lordship. So some time will be required.
All right, hard disposal. Disposal.
30 is same, my lord.
Same, Lord.
30 is also same.
Same, my lord.
Yes, sir.
Twenty-nine, 30. All right.
Obliged.
May it please your Lordship. In this case, additional Advocate General P. Nayak will lead us, Lordship. So I pray for adjournment today, Lordship.
What do you say, Mr. Ghosh?
My lord, what is they have my lord wait and prayer. My lord, immediately after vacation. Otherwise, my lord, the matter is very, because we have challenged the propriety of the search and seizure procedure as well as the my lord, inquiry proceeding followed the search and seizure. The matter is long pending. That is the pen. One is of 2023 and 2024. My this is the only I have, my lord, because they are unable to operate.
On the request made by Mr. S.R. Purva, on behalf of Mr. K. Nayak. P. Nayak.
P. Nayak.
That,
May I pray?
additionally, the matter can be referred to the legal.
May I for the second week of May, to be convenient.
Why?
Pray for my lord immediately after pray. I'm also
6th of May. 6th of May.
So
6.
6th of May.
Lord.
It's a Tuesday. Matter be listed for admission.
obliged.
My lord, this is non-payment of higher charge, my lord. What I pray before your lordship, my lord, it has been listed several times, my lord. Let them examine and verify, my lord, whatever I am entitled, that be given to me, because I have
I
borrowed.
have talked with the authority so further time.
My lord, let them ultimately it will be
Verify
like
and pay whatever is there.
Lordship, let the instruction come and I'll file affidavit, Lordship.
Affidavit.
my lord, either my lord, they have to examine
Because,
and
Lordship,
verify. My lord.
more
If
than
affidavit comes out.
2 crores bill, Lordship. So
All right, we'll have it immediately after vacation. You get instructions whether these amounts have been raised and found to be genuine or not. That's all you give us. Whether the bills have been raised in connection with the vehicle by the particular office. That in
admitted due bills. Admitted due bills what
admitted or not will be subject to verification.
Lordship. But that's why, Lordship, they have communicated to me that verification
29th.
is going on.
Let us have it on 29th. 29th of April.
29 of April. Can it be on first week of May, Lordship?
What difference does it make first week of May?
My lord, let it be on 29, my lord.
No, 30th of April.
Lordship.
On that day, my lord,
Please,
hand
that
over
will be
to be
listed on
made to
30th of
dispose of, my
April
lord.
as on the request of Mr. S.R. Purva, that the instructions in respect of the writ petition are awaited. PI for 30th of the petition. List on 30 April.
On that time, my lord, endeavor to be made to dispose of my
An endeavor will be made to dispose of the requested on the next day fixed.
all blessed.
God bless you.
That is one of the matter pertaining to the settlement of the property.
IA has been filed. IA.
I filed my here, the response number 5 and 6, the president and secretary of the Union Committee. This settlement was made in the name of the Union Committee, as per Annexure 6, page 53, my lord, for the order. So this, we are making both secretary and president the party. Secretary, he died, my lord. Even the mistakenly, he was made a party. Because it is not necessary to make a party because the settlement was made in the name of the society, my lord.
So his name should be deleted.
Deleted, my lord.
All
For
right.
deleting his name, we are filing this higher, my lord.
Heard IA number 1146/2025. This IA has been filed seeking an order for deletion of the name of the respondent number 6, Hiren Bora, who had since expired and who was holding the office of the secretary at the relevant point in time. Counsel appearing for the respondent does not. Any objection, Mr. Counsel, for the respondent?
Copy was not served on me, my lord.
So we have not served to the case, sorry.
Probably to the government.
Minister, I tell sir, my lord. That is the only PR, my lord, to delete the name, my lord.
You are
Nothing more.
representing whom?
I am representing my lord, respondent number 5, my lord.
Respondent 5, President.
Lordship.
So you should know whether the secretary was alive or dead.
No, my lord, this petition has been filed by my lord, petitioner, my lord, and page 5 of the petition, kindly see, my lord. Here it shall be written, my lord, Hiren Bora since this is, my lord.
That is why we are deleting it. It is mistakenly made, my lord.
Page 5,
I
my
am
lord.
writing in the IFA.
Document number 6, my lord.
The counsel for the petitioner. Counsel for the respondent does not object. Counsel for the petitioner submits that the respondent 6 was wrongly carried as the party respondent. This has already expired. This had happened before oversight. So therefore the IA has been filed seeking deletion of the name of respondent. Error having heard the party and upon considering the prayers made, the IA says allowed name of respondent 6 is deleted since it is submitted that the state respondent already expired before the filing of the writ petition. Accordingly, IA says allowed this photo amended post title to be filed within 2 weeks. The writ petition you write in view of the order passed in IA. Number so and so, respondent 6 name stands deleted. Petitioner will file amended post title within 2 weeks. List the matter accordingly. Yes, after 2 weeks.
But they made, there is a order for consideration of the interim PR today, my lord, because the settlement was made in my name.
We
I
have
am
passed an
collecting
order
revenue.
here, you'll have to file amended post title, all these defects will have to be cleared. You're deleting somebody's name.
My lord?
You are, respondent 6 name has been deleted.
Yes.
So you have to file an amended post title in the registry.
Post title in the, of the petition, my lord.
Yes,
No,
amended.
it may be directed to correct it, my lord.
No, no,
Correct
not
that
like
way.
that. Not by hand.
Post title, yes.
You have
It
to
may
file.
direct it by deleting the name.
You have to file a fresh post title, amended post title. Otherwise, it is not accepted by the computer.
Amended post title petition. Petition file for
Matter be listed on 25th of April.
Make it 21st on the reopening day of
All
the.
right, 20, no, but when will you correct it?
When will you correct? So,
You will require some time to file the amended post title.
No, I'll file it there. All right. After vacation, it will.
Yes, 25th of April.
All right.
Item 35.
May I please your lordship? Few days back, we have received an affidavit in opposition filed by the railways. Lordship may allow us some time to
Counsel
file
to
it.
the petitioner
to
take
reason.
liberty to file reply affidavit, the affidavit not filed with the response. List again on
Lordship, if you say
21st,
that because there is interim order.
21st of April. Interim order passed earlier will continue till the next date fixed. Mr. P. Chakraborty appeared to the learned CCC for the respondent.
Supplementary for admission item 40.
Lordship, this is item 440. Lordship, there, regarding this case, there are some similar matters with similar subject matter itself. Lordship had also disposed it of, and as well as there are some other judgments, same High Court, that were disposed of by Honorable Justice Michael.
Where is the petitioner? Give us a copy.
Lordship, there are two copies right here. There are some more.
4543.
4543. Yes, sir. 5433. PW2. Paragraphs 8, 7, and 8.
Petitioner is not available here.
Good.
None appears for the petitioner, Mr. M. Yeah, the response matter passed over for the day.
Much better.
Items 41 and 42.
May I please, Your Lord? Before I go to the impugn order, my lord, I will take a lordship to annexure B, my lord, page 22. The lordship has passed the order, my lord. Matter relates to the illegal issuance of demand of notice, paragraph 2, my lord, page 23. The grievance of the petitioners in respect of notice of demand dated so issued by respondent number 3, where an amount of rupees so was demanded as an amount was providence on payable by the petitioners to the respondent authority. The details of the amount payable are enclosed to the communication annexure A. Learned Counsel petition submits that the petitioners had earlier preferred a writ petition being number so and submits that an order dated so was passed in WPC number so where a notice of similar nature was issued. This court by the state order has suspended the enforcement of the state notice till the next returnable date. Subsequently, on 31/7/24, on the basis of instruction by the PF authority, the writ petition was disposed of on the ground that in terms of the communication placed before the court had the earlier input notice was considered to have been deemed to be withdrawn. My lord, next paragraph, only learned counsel for the petitioner submits that a communication dated so was issued by the respondents putting the petitioner's notice he has failed to pay the monthly wages and clarify the amount of so. So, my lord, the dispute is regard to 22 lakhs, my lord. So, thereafter, lordship was pleased to next page, lordship will find at page paragraph 6, my lord. Lordship, meanwhile, in the event department proceeds in the matter in respect of the notice of demand, so issued to the petitioner, no final order shall be passed. Now, what has happened during the pendency of this proceeding, my lord? The respondent authorities, without taking any permission of this honorable court, my lord, attached my property. All the more than 15,000 bighas of land, my lord, they have attached. And my lord, the problem is that when I was intending out of these 15,000 bighas of land, I was intending to sell at least 100 to 200 bighas of land so that I can pay off their dues. And knowing that, my lord, they are up to grabbing my whole property, my lord. So, my lord, thereafter, lordship will find 47, page 47.
What has happened to the writ petition?
Sir, these are pending. They have neither filed any affidavit, nothing. Lordship may kindly come, I have come on in contempt case, my lord, 47, page 47. Contempt is preferred for violation of interim order dated so. It is submitted that interim order this court
Which
has
is the
direct-
order, impugned order here, page 26.
Page 26, yes, my lord. So they should have at least waited for me to give the dues, my lord. I am in fact, they are making my life miserable, my lord. Every day calling me, give. Where from whom I will give, my lord? So somehow I could pay the laborers this holy, my lord, their wages and everything. My lord, my prayer is that limited prayer, let them withdraw this order of attachment or lordship may set aside. I give the undertaking that I will pay the dues within 2 months, my lord.
because I am intending to sell a portion of, a minor portion of the land, ma'am, so that I will give the whole amount without any dispute. The whole amount I am ready to pay.
Yeah.
Just this much of.
Your lordship, order was only to proceed, not to proceed with the demand notice, but not to take final order. We have not even issued auction notice. Here we have only because for attachment is for the protection of the PF. 22 lakhs is not the due, it's 1 crore 20 lakhs. It's one, the demand notice is one.
But you knew there was an interim order.
Yes, we have not done anything. He is running the garden. We are not running the garden.
No, but you are attaching the property.
Attaching because there will be no security, your lordship, because
Whatever you want, you should have come before the court that you want to proceed in view of this, whatever.
yes,
apprehension you have.
your lordship has given the liberty to proceed.
No, we have given you the liberty to proceed
Not
and
to
no
take final order. No final order. Final order is
Don't play with the words.
No.
The purpose of not having any final order means that you are not coming to a conclusive decision. Now, if you go for an attachment,
attachment is only for if a lordship sees the
how have you
attachment.
valued the land?
No, we have not even issued auction notice.
Auction comes later.
Yes.
First, you have issued the attachment order.
Attachment is only he is running and managing the garden.
Why have you issued the attachment?
So that otherwise the PF amount would not be protected.
On what basis? How do you intend to protect the PF amount by
Because if
attaching
your lordship see the third paragraph, page 20.
it? 20.
Yes, page 20.
Yes.
You are informed that in case of failure of deposit asset use, state will be taken to realize the same amount in accordance with provision section 15, which you have not even initiated, your lordship. Scheme as amended. In addition to the said amount, you are liable. This is a notice of demand. Then your lordship will come to the attachment order at page 26. This notice of demand has not, lordship will come to page 26. We have not even appointed receiver also. He is
My lord,
managing.
already contempt has been, cognizance has been taken, notice issued. My lord, they have
Yes,
dared
your
to
lordship may-
not take the permission of this honorable court, my lord. And no affidavit, nothing has been filed, my lord.
Lordship may turn to page 26, the attachment. If I may read your lordship, page 26.
But you should have approached this court when there is an interim order.
You only he is prohibited and restrained from selling the garden.
That's all right, but
Yes.
where is the finding? Where is the finding that this is the amount required and
In the notice of demand.
no, but
In the notice
this
of demand.
property which you have attached will be sufficient to give you the if sold. Where are all these findings?
That will, after attachment, the procedure is
You can't go on attaching a land without even making an
15,000
elementary finding
Yes.
as to is there let us go back to the demand notice.
Demand notice is 1 crore, page 20 your lordship. And 21
Is there any specification in the demand notice?
Yes, page 21.
That till you are able to pay the amount, you shall not alienate the property.
That is under the law, which says, because as soon as he is unable to pay, the second procedure is attachment, your lordship. Then, but anyway, lordship, I will, let me file my affidavit is all ready. Let me file my affidavit because today it has come for the first time after issuance
It
of
may have
notice.
come for the first time. What we are asking you is that you are aware of an interim order, whatever some order was passed.
As
if
of-
you want to take steps which requires an interpretation, you should have approached the court
That may be,
seeking leave.
yes,
That
maybe,
we want to proceed for attachment because of this reason.
Because
Perhaps the
our
interim
understand-
order could have been vacated.
yes, no. Pay order may be in his favor, your lordship. That may be our, but means we have not even issued the auction notice.
You
We
may
have
not
only
have
attached it
issued
so that it is protected. Otherwise, the PF dues would be, there won't be any ways to recover the PF due.
Then you should have brought it before the
Yes,
notice
that
of the
may
court.
be. We'll file a affidavit. Let us give an opportunity to file a affidavit.
No, my lord.
No, you have bypassed an interim order.
If your lordship sees an interim order, page 25.
Yes. Proceed in the matter, but not to pass a final order. Unless you proceed in the matter.
Yes.
And you quantify the demand and the amount which is recoverable. How
That
it
is at
to
page
be
20.
paid.
It's with the
That's
demand
the
notice.
demand.
Yes.
On what basis are you attaching the land? Have you made any assessment that if this land is auctioned off, this demand will be paid off?
Your Lordship, there are three ways to recover. One is for attachment, then auction. If it is not recoverable, then we can go against his personal assets also. But first is always to attach and give it to him. He's managing. He's not even interfering with his management of the tea garden. He's selling the tea leaves. He's still paying the laborers. He's doing everything. It is only that so that he
The
does.
order is very clear, no final orders without leave of the court.
It is not a
What is
final
the meaning of that?
This is final order. Our understanding was, Your Lordship.
Your
greatest
understanding
humility
is not, may not be the correct way, at least you should have approached the
Then
court.
I apologize, Your Lordship. Our understanding was.
You should have approached the court by filing a proper application. This is, it is as if you have unknowingly made a mistake, but since you have already made a mistake, therefore let the mistake be in place. This is the essence of your submission. There is an order, you represented. If you had a doubt, you should have filed an application. Why did you bypass the interim order? Assuming it is a wrong order, you have forums to get it corrected. But this order sustained is on date today. Why?
Final order, in my humble opinion, is only when we sell the garden after auction. Or because, Your Lordship, even if we issue the auction notice, you will still get a chance of redemption of 30 days.
That's a matter of interpretation.
I can maybe let us give us time to file a report. Our affidavit is ready.
Lord, I pray for interim, my lord.
What interim?
To stay the operation of the impune order.
How does it affect you?
My lord, because they knowingly, my lord, more than 15,000 bighas of land, my lord, and 1 crore 12 lakh.
How are you affected? You want to
Because
split off?
yes, portion of the land.
You show us by way of an affidavit given undertaking that this amount which you will sell is meant to be used for payment of the PF due. Where is that undertaking?
Lordship, actually, I'll give my lordship my record my submission. If
No.
necessary.
We don't record submissions.
But apparently, my
Have
lord,
you
they
made
have
a statement in the writ petition?
because subsequent development, my lord.
Have you made any statement in the? You have come before the court challenging this order.
Yes, my lord.
Have you made a statement that if you are allowed to sell off the amount will
Lordship
be?
may kindly see the order of attachment that they have passed, man, that is illegal, man. And they cannot just attach the whole land, my lord.
The counsel for the respondents will file necessary affidavit in the matter. Matter be listed after 2 weeks.
My lord, then I.
The liberty is granted to the writ petitioner to file necessary affidavit. If so advised, to the effect that to show how he intends to pay off the PF dues in terms of the demand notice dated so and so issued by the department. Matter be listed on 25th April.
My lord. In the second case, there is interim order. Second case, no?
42.
Yes.
Interim order is already there.
Yes. May continue.
Interim order passed in this matter. We continue the next day. Matter be listed along with item number 41. The respondents are permitted to complete their pleading if so advised in both the writ petition.
Wait, Your Lordship. The matter relates to payment of pending dues of the petitioner, my lord. If Your Lordship should kindly come to Lord, page number 28. That is the work order, 5961. Page 28. Yes, sir. With reference to the subject cited above, please find herewith and confirm order for supply of promels on hire basis with capacity of 300 MT per day with 75 to 100 mm of screening to Guwahati Municipal Corporation at the offered rate of lowest quoted bid dated 2921 as shown below.
Now, Promel with capacity of 300 metric ton per day with 75 to 100 of screening. Monthly rate rupees 14,45,000. Quantity 1. So this was the basic order, Miller. Now thereafter, the work order was extended from time to time. Page 32 is one such order, Miller. It was on 23/6/22. With reference to the subject cited above, please find herewith the confirmed order for supply of Promel on hire basis with capacity of 300 MT per day, each with 30 to 40 millimeter and so of screening to Guwahati Municipal Corporation at the offered rate of lowest bidded port dated with effect from 5/4/22 as shown below. So this was one extension. Then, my lord, the second extension lordships will get at page number 60.
Yes.
It was on 13/1/23. In continuation of order as referred above, your work order under reference has been extended for another 2 months with effect from 9/1/23. Same terms and conditions. Then, my lord, the next extension order is at page 63. This was on 9th of March 2023. In continuation of the order as referred above, your work order and reference has been extended for another 2 months with effect from 9/3/23 under so and so terms and conditions. Then, my lord, the last extension order is at page 81. On 1st of June 23, in continuation of order as referred to above, your work order and reference has been extended for another 1 month, that is 9/5/23, under the same terms and conditions. Now, my lord, after I submitted the bill, certain issues were raised regarding my performance, etc. Then an order was passed on 19/4/23 at page number 83. This is the minutes of the meeting for clearance of outstanding liabilities of hired labor for desiltation work held on so and so in the conference hall of office of the commissioner so and so. Now, if your lordships would kindly come to page 84, para 8. The committee verified the bill submitted by Northeast Environment Technical Private Limited, white file number so and so. The members verified the documents and observed the logbook recorded by JTO and Executive Engineer Division number 6, wherein it reflects that machines were not working at that time. As such, committee recommended that the bill cannot be considered for payment. Now, this is how, my lord, this approach was adopted. Eventually, my lord, if your lordships now kindly comes to the affidavit in reply of the petitioner at page number 114. I'm just not troubling your lordships with the other details. 114, Miller. This was the last of the decision taken. Now they realized that our earlier stand was wrong. It was on 18/7/24.
Yes.
Minutes of meeting of clearance of outstanding liabilities for the work, hiring of 2 number of Promel with capacity of 300 MT per day, each up to so and so, held on 18/7/24 in the office of the Joint Commissioner GMC. The meeting was presided over by Joint Commissioner Guwahati Municipal Corporation. The committee was informed that today's meeting has been convened to discuss on the pending bill for the work hiring of 2 number of so and so, for the period from 9/3/23 to 8/6/23. The processing of the bills are pending for a long time due to lack of collective decision over the issue of lesser output of the hired promel engaged for waste processing in Belortol dumping ground. Since there was no clause regarding any threshold performance output and neither there was any specific condition in RFP for deduction against such condition, the concerned engineer had put up the file for a direction from the authority regarding this because the output of the engaged promel was less. That was targeted due to various field constraints and adverse ground conditions. After threadbare discussion among the officials, the following decisions were taken. The committee discussed the details of the nature of the work carried out during the execution time. The work was executed in accordance with the systematic provision of component of waste segregation process using Promel at Belortol. From record, it has been found that the daily targeted quantity of waste processing could not be achieved due to systematic difficulties and adverse site conditions. On detailed discussion and from the input from the site engineer, it was accepted that output of the Promel was dependent upon many factors, including supporting materials and service from part of the employer. It was also observed that there is no any specific condition in the contract for deduction of any amount for contractor's bill for less output than the targeted output. Considering all the conditions and ground reality of the unorganized dump site, the committee decided to recommend for release of bill of the contractor without any deduction for lesser output of the Promel against the daily targeted one. However, all other deduction at source will be made as per rule. The concerned engineers will process the bill accordingly and submit it for releasing the payment. Meeting ended with a vote of thanks. Actually, my lord, adverse site condition, there was no such condition. My lord, it's very unfortunate, my lord, they avail the service. When it comes to payment, because they don't have the resources, they always take up this fee. My lord, under section 70 of the Contract Act, I have not done this gratuitously, my lord. This is a contract, commercial contract. That on the basis of this, my lord, my payment should be cleared. That is my case, my lord.
Second decision, my lord, Lord will quote the decision of that dated, my lord, it is 18/7/2004, and direct the commissioner to release the amount. Because they have already taken a decision later on, my lord. So they are not, my notes of the meeting dated 18/7/2004 makes it clear.
Again, assisted by Mr.
My lord, as authority.
Yes, sir. Okay. And Mr. Yes, sir. Yes, Bora. The respondent. Agree. I did not please of the bills raised for works executed by the petitioner. It's a company registered under the Companies Act of 2015 and is a small enterprise as per the Micro, Small and Medium Industry Development Act 2006. The respondent authority had issued work order dated 4/9/2021. Both the work orders are of same date.
Yes, my lord.
Work order dated 4/9/2021 ID. Work order number and work order numbers with for a period of 6 months.
My lord, both the work orders not of same date, my lord. In item 6 to 4 case, work order is dated 22/12/20. And in this case, work order is
How many-
4/9/21.
How many matters do you have?
Lordship is taking up
5961. In 5961, work order is dated 4921.
4921.
Yes.
What is the number of the work order?
One second.
Page 28. Your Lordship.
2A.
Wait.
It's GER/division dash Roman 6/56.
Page number 20. By the said work order. Petitioner was awarded the work for supply of promels on higher basis with capacity of 300 metric tons per day with 75-100 millimeters of screening at the rate offered by the petitioner was declared as the lowest rate given. The terms and conditions in respect of the usage of the promels and the payments thereto are specified in the work order itself. How many promels were used? Two.
Yes. Initially one, then two.
No, then why so many work orders from 28, page
It
number
was
20?
extended, my lord. Initially was for 6 months.
Oh. The work order was initially issued for 6 months.
Yes.
Subsequently, it came to be extended from time to time by each one of them.
The last extension was up to, my lord, 63 minutes, 85. No. One second, my lord. From 9/5/2081. My lord, the last extension was for 1 month, that is 9/6/23. 8/6/23, my lord.
86.
23.
Page number?
81, my lord. It was only for 1 month.
Last extension was made on, I think it is
1/6/23.
1/6/20. Last extension was 1/6/20.
8/23, my lord. For 1 month.
The work was duly completed.
Yes. Only dispute was, my lord, that according to them, the extent of work we did was not according to the contract. That is not the position because their own minute says, my lord. There was no such stipulation. And secondly, my lord, the site conditions were such it was not possible to conform to the requirement. And these are all, my lord, underdeveloped areas.
The work,
The idea was to segregate those, my lord, wastes.
the work was duly completed by the petitioner. However, after bills were raised, the same remained pending without the respondent releasing the amounts stated to be payable to the writ petition. Ultimately, the matter was decided by the DMC in the minutes of the meeting for clearing the outstanding liability of the work allotted to the writ petition. By the same minute, the committee decided to recommend for the release of the bills of the contractor without any deduction or lesser of the promels as against the daily targeted one. Mr. Reyes Bora submits that since the committee has already resolved to clear the bill, the writ petition can be closed, directing the respondents to clear the bills. Without clear the bills as per procedure. The learned counsel for the parties have been heard. Meetings have been kept. Perus. It is seen that there is no dispute that the petitioner had completed the work allotted. The initial order was subsequently extended from time to time. The various terms and conditions under which the work was to be executed are mentioned in the work order itself, including the extension subsequently issued. From the pleadings available on record, it is seen that the dispute between the petitioner, dispute raised by the respondent at the time towards release of the bill was on the ground that whether any deduction was called for in respect of the lesser output of the tromels as against the daily targeted output. So, although initially there were different views in the department, ultimately by the minutes dated 18/7/2022, the department agreed to release the bill. So, the minutes dated 18/7/2024 in the respected case number 112. Having heard the counsel of the parties and view of the submissions made and taking into consideration the submissions made and also the minutes dated 18/7/2024, this court took the view that the writ petition can be closed at this stage with the direction to the respondent authority to ensure that the bills raised by the writ petitioners in respect of the works executed for the work within quotes, hiring of numbers of tromels with capacity 300 MT per day, each with 30-40 mm and 75-100 mm screening. Quotes closed. As expeditiously as possible. The amount should be released within a period of, within the outer limit of
3 months. 3 months.
3 months. 3 months from the date of the certified copy.
My lord, in the second case, the work order is dated 22/12/20 at page 35. And my lord, page 64 is the work completion certificate.
Yes. Work order is at
Page 35.
35.
Yes.
35. Work order dated 22/12/2020. And work completion certificate?
Yes, page 64, my lord.
64. Work completion certificate dated 7/6/2020. In the earlier matter, is there any work completion certificate?
No, there is no dispute on that. There, my lord, the dispute was regarding less output.
Therefore, it need not be referred to.
Yes, yes. That need not be. In the
Work completion certificate. And the minutes is the same. Minutes is the same minutes.
same minute.
Page number 86.
Yes, my lord.
No.
Here, my lord, there is no issue of minutes. Here, because similar issue was pending there, therefore this was also written.
Dispose of.
Yes, in the same
by
line.
Common order.
Common order.
Commissioner will
Only lordship will indicate the work order is different.
Commissioner will come in and
Hey, that's been